Chief Justice of India, B.R. Gavai, outlined the core dispute before the Supreme Court as it delivered its opinion on the powers of the governors in clearing state bills. Now, CJI identified that the governor has no power to simpliciter withhold. Therefore, discretion so conferred cannot allow him to hold bills in perpetuity. The three clear options he has is to either grant assent, withhold assent, and return the legislature with comment or refer it to the president. He has a discretion in choosing any of the three options is what the Supreme Court has said when referring to the cases and pleas surrounding this and giving an opinion on how the powers of the governor as well as the president functions when it comes to the assent to be given to bills passed by the legislatures. Although the Supreme Court held that governors cannot indefinitely block state bills, it refused to set any time limit for governors and the president, saying that doing so would be against the separation of powers. Now, the Chief Justice said that the first question was how many options the Constitution gives a governor when a bill is presented. The submission is that the next is explicit upon presentation. The governor can assent to the bill or he can withhold, therefore, or reserve for the president, he said. Now, according to one interpretation, the CJI noted that the first proviso, according to this submission, is an additional option, making to the total 4 options available to him. The opposing view, he added, was that the governor has only 3 choices: withhold, assent, or send it to the assembly, and if the House passes, the governor is bound to give assent. He said that the second interpretation is to bind the first proviso, in which case the governor is given 3 options. In that view, the governor can assent, reserve, or withhold, therefore, and return to the legislature and then pass. The bench clarified that the 4-option reading would apply only when the legislation is not a money bill. Now, for more on this, I'm joined by Sabyasachi. Sabyasachi, interesting observation, and with regard to the opinion that the Supreme Court has given, it has not technically given a time limit, but at the same time have told the executive bodies of the Constitution, such as the governor and the president, that you cannot technically sit over a bill for very long, but there is no time limit to it. So it keeps it open, isn't it?
Well, that's right. See, in the opinion and advisory that has been given by the Supreme Court today, the Supreme Court clearly stated that the governor has 3 options. Either he gives assent, either he refers the bill to the president, or he refers the bill back to the assembly. Now, there is no 4th option of withholding the bill for an indefinite period of time. Now, the Supreme Court also has given a bit of relief to the non-BJP ruled states, stating that if the state feels that the governor is sitting on a bill for an indefinite amount of time, is withholding the bill, then the state can reach out to the Supreme Court, and under these circumstances, the Supreme Court can intervene. But when it comes to the fixing of a time period, the Supreme Court clearly states that under Article 200 and 201, the governor has certain amount of flexibility, and that cannot be challenged. In fact, the Supreme Court also pointed out that no constitutional court, in fact, can give an assent to a bill. In fact, in the month of April, we had seen that while the case was going on between the governor and the Tamil Nadu government regarding the withholding of bill, at that particular time, the 2-bench judge in the Supreme Court, they had fixed a time period of around 3 months, and under these 3 months, some of the bills were passed. But that clearly won't be happening, because the Supreme Court clearly stated that no constitutional court has the right to give an assent to a bill. That power completely lies with the governor. That cannot be challenged. Now, these were some of the important opinions that the Supreme Court has given. But at the end of the day, these are just opinions and observations that has come in from the Supreme Court. These are not mandatory law. But it's a 50-50 win if you see both the centre as well as the non-BJP ruled states, because earlier the centre had clearly challenged, stating that the court cannot encroach as far as the constitutional position of the governor or the president is concerned, that no constitutional court can encroach it. So it's a win-win situation for both the centre as well as the non-BJP ruled states. Whereas clearly in the opinion, the Supreme Court has stated that these are the 3 options that the governor has. He cannot withhold the bill for indefinite period of time. He has to pass the bill back to the assembly, and after that, once again, the assembly refers the bill to the governor, and the process takes place.
Sabya, Sachi, the big story over here is that isn't that the SC is taking a very cautious approach when it comes to ensuring that the executive's powers are not usurped in case they have to give some kind of a verdict on this. So they're trying to tread a very fine line on the separation of powers, isn't it?
Well, definitely. See, the Supreme Court was extremely cautious. In fact, it is not a verdict, it is an opinion. It's advisory that has been given. It's not a mandatory law for the governor to follow it. The Supreme Court says that there are not four options that are there with the governor. The governor has three options. But the Supreme Court at the end underlined that, the statement stating that if the non-BJP ruled states feel that the governor is sitting on one particular bill for an indefinite amount of time, then that particular state government has the complete right to reach out to the Supreme Court, and the Supreme Court will intervene and ask the governor to take action. Now, the main point of the Supreme Court is that you cannot sit on a bill for indefinite amount of time. You have to take action. You have to take action. Though the Supreme Court also giving relief to the governor and the central government, stating that there is no fixed timeline, and they have clearly said that the action of the governor cannot be challenged in the court. So that also the Supreme Court has mentioned. So overall, it's a very cautious approach that has been taken by the Supreme Court. Meanwhile, in the month of April and after that also, be it the Tamil Nadu government or the government of Punjab, all of them have reached out to the Supreme Court complaining that there are a lot of pending bills with the governor and there are no actions. So as far as the observation or opinion is concerned that has been given by the Supreme Court, it's a relief for the state government as well. It's a relief for the central government as well.